A recent court ruling has transferred funding for primary and secondary schools from State Universal Basic Education Boards, SUBEBs, to the Universal Basic Education Commission, UBEC, requiring local governments and communities to access these funds directly without intervention from state authorities. The decision has sparked debates over the potential impact on education quality, administrative efficiency and accountability at the local level. Well, joining us from Abuja to examine the implications of this landmark ruling, its effect on school funding and how it could reshape education administration in Nigeria is Barrister Sesugh Akume, public interest litigant, who will provide insight into the legal, social and operational consequences of the ruling. Welcome to Newsday. Thank you so much for joining us.
Thank you for having me.
So what is the legal and constitutional foundation of this court ruling, and does it effectively override existing state laws establishing SUBEB?
Yes, this court judgment establishes what has been there already. What has been there. The thing about our laws are that they're sort of contradictory. Some are clear, some are not clear, some are contradictory. But even the ones that are clear are sort of made to be ineffective. So the local government has already been established as a third tier of government that was already established from the beginning. And it is supposed to be run by democratically elected officials. That's been established by over time. And then when you go to the fourth schedule, it already establishes the roles of the local government, the things they're supposed to be doing, and so on and so forth. But over time, these things have been eroded, and therefore you now have a state government that treats local governments as if they are agencies of the state government. And as of last year, on 11th of July, the Supreme Court judgment consolidated all its previous judgments. That wasn't the first time the Supreme Court had said this, but for this time it brought out certain punitive elements to it, which is why it's sort of like the reference. Otherwise, it had just repeated itself what he has said over time. That the local government is a third tier of government. It is not a subsidiary or under the state government or an extension of it, and therefore should operate autonomously. Autonomously means that in the same way, the federal government doesn't tell state governments what to do, how to go about it, and so on, is the same way that states cannot be controlling local governments. And so so that's what's established in the Constitution. Now you have the UBEC law, the UBEC Act of 2004, which had contradictory elements to it. When you go to section 11 of the UBEC Act, it now said, okay, by the way, the UBEC Act is very clear that the job of UBEC is to help states and local governments in providing universal basic education, free compulsory universal basic education, which means that every child is supposed to have free education, and it's compulsory. And it even says that it's the job of officials at the local government to enforce this, that any parent or guardian whose children or wards are not in school would be taken to court, because it is compulsory. Every child has to have primary education and junior secondary education. And it now establishes the local government education authority, establishes the state's universal basic boards. And then it now says, in that section 11, it now says that the federal government is going to be providing funds to help. It is very clear that it's to help these providers of universal basic education. Now, the federal government is going to be providing 2% of its consolidated revenue funds for this purpose, dedicated for this purpose. Now, the states and local governments who are providers of universal basic education are to contribute 50% of whatever amount they need. Let's say they need 100,000 naira, they'll contribute 50,000 naira. UBEC will now double it and give it to them. That's the cash part, even though UBEC plays other roles. Then, section 11.2, which no longer exists now, Section 11.3 now went ahead to say that for local governments to access these funds, for states to access these funds, It's states that will access the funds. It doesn't mention local governments. It only says it's states that will access the funds, which means that local governments cannot access these funds except the SUBEBs apply for the funds on their behalves. So that's one of the things the court judgment took care of. The court judgment also went ahead to section 13, subsection 1, which established the SUBEB and the LGA, that's the Local Government Education Authority. SUBEB is State Universal Basic Education Boards. Section 13.1 said that the local government education authorities were subject to the supervision of the SUBEB. And the court said no. The local government is a third tier of government. It is autonomous. An agency of the local government cannot be subject to the agency of another tier of government. That's what the court said. So this corrects a lot of anomalies, because right now in Nigeria, there's no local government that has teachers, that has non-teaching staff, that has they don't have control of anything. As a matter of fact, even the local government education authorities, the education secretaries at the local governments are staff of the SUBEB who are posted to the local governments. This is an anomaly. So breaking it down now, we have 18 million children out of school. We have schools that are dilapidated, classrooms are dilapidated, and children not going to school. Some schools have only one teacher. That's why many schools are dead, and that's why we have many children out of school in the first place. And then when the economy wasn't as terrible as it was now, parents used to pay PTA levy, for which the schools contributed and hired teachers, and they were paid from the PTA levy. Now parents can't even contribute that PTA levy. And by the way, the UBE Act prohibits collecting PTA levies in UBE schools, that's primary and junior secondary schools, in the first place. And it even penalizes anybody who collects that money. It is supposed to be completely free. But because the SUBEBs because of what they have done over the years, there's nothing anybody could do than break the law to make a way so that children can be in school. Now the economy is so bad that they can't even pay, and so you have even more children out of school. When you go to the states now, the respective SUBEB laws for each of the states, they have laws that make it impossible for the local governments even for the local government education authorities, which supervise the primary schools, and they're supposed to also supervise the junior secondary schools. They can't even provide chalks or markers or whatever. They can't do anything except the SUBEB in the state headquarters procures it and sends across. I know I'm talking about procurement now. You know what goes into that. And so nothing goes on. But with this, with the court making it explicitly clear that no, the local government education authority is not under the state universal basic education board, now the local government authorities, and he also made it very clear that the local governments should directly access whatever funds that they need directly from UBEC, not through this SUBEB any longer. It solves so many problems.
Now,
UBEC has been complaining every year that there are hundreds of billions of naira for universal basic education that have not been accessed. Right now, this opens the door for local governments that want to simply approach UBEC directly to access these funds. And the court was also generous to say that.
Allow me to interrupt you. I'm just wondering how this ruling might affect states' obligation to provide counterpart funding. How would it affect that?
So it does not affect states providing counterpart funding. It doesn't stop them from providing counterpart funding. The difference it makes now is that the states would send the counterpart fundings to respective local governments instead of running, because before now, what the states did was, if there was any counterpart funding at all, which I doubt, but if there was any at all, the states would sit together and decide how it will be spent on behalf of the local governments. Now, what the states will have to do is to send the counterpart funding to the local governments in the same way the federal government is sending to the local governments. The states sending counterpart funds to the local government takes further universal basic education, because the state has too many things to do. Some of them have universities they are running, they have secondary schools they are running, they have adult and non-formal education and so on. So because this is the core duty of the local government, it only makes sense for the state to fund the local governments to do that part, and they can focus on other important things. It only takes it forward. It doesn't take it backward. So that's what it does.
So what is the legal status of SUBEB now following this ruling? Has it been abolished? Is it weakened or merely bypassed? What's the state of SUBEBs going forward?
Because education is on the concurrent list, which means that the federal government and the state governments make laws pertaining to education. This judgment overrides whatever the state laws have. So if the state laws have said that local government education authorities are under SUBEB, which is what they've done, because, like I said, because it is on the concurrent list and both the federal government and the state government can make laws pertaining to education, the Constitution says that laws made by the National Assembly are above the laws made by the State Assembly. So now that the law, that's the UBE law now, by the National Assembly, now that it's clear, the court has interpreted it to mean that SUBEBs are not, LGAs are not under SUBEBs, it means that is what is, because the UBE law is above the state laws. So that is what it means. What this means in practical terms is that SUBEB, whereas they cannot henceforth hire staff for local government education authorities, cannot spend monies on behalf of local government education authorities, it cannot access federal grants on behalf of local government authorities, it can still play important roles. For instance, the aspect where you mentioned about states also helping local governments take care of primary education and junior secondary education and so on, they can play those roles as well and so forth.
So could this decision set a precedent, for further judicial intervention in state-managed sectors?
Precisely, because when you look at the judgment, I'm sorry to say this, but it has to be said on the record. Unfortunately, I'll premise this before I answer your question because it's important. We don't want systems to work in Nigeria. That's the problem. We don't want primary education, secondary education, local government autonomy to work. That's why we keep having to fight all these fights. You'll be surprised to find out that after the Attorney General went to court to get the landmark Supreme Court judgment that granted local government autonomy and consolidated everything, it was the same Attorney General who was in court fighting this particular lawsuit and resisting for local governments to directly access funds from UBE, which was a contradiction, which the court noted that it's a contradiction. And the court said that the local government is an autonomous tier of government, and the National Assembly has no right whatsoever to subject a local government agency under a state government agency. This applies all across. So this same thing we're talking about here in education happens in health as well. All primary healthcare centers are under state primary healthcare boards, and the same reasons why our primary healthcare centers are not functional and so on and so forth. So this applies, the principle applies everywhere, that local government agencies cannot be under state government agencies. They are autonomous. So it applies in everywhere else. But the point I was making earlier was, because we do not want the system to function, there'll have to be lots of fights and lots of steps taken forward to make sure that this thing works. But I think it's part of the role of being citizens, and that's the role. If citizens want and interest bodies want, these are things that will have to be worked over time so that the local government can be free to actually do its work. Because if the local government system were functioning, lots of things would go on smoothly. It wouldn't be, it's not the duty of the state government, for instance, to collect refuse, to do so many things the state government does. That is the job of a local government that should be doing it. If the local government is doing that, the state government is doing it, the federal government will focus on other issues and the system can be running. It's not for state governments to do the role of the local government and federal government to be doing, the whole thing gets mixed up. And then it also happens that because the system is run like a unitary system, for everything we think it's the duty of the president to have done this, the duty of the president to have done this, or the duty of the governor to have, no. Different people have different roles and different responsibilities that everybody's supposed to be facing so that the system can run.
Well, thank you so much for this insightful discussion. Barrister Sesugh Akume, public interest litigant, thank you so much for joining us on Newsday.